The bailiff's voice cuts through the air. Please be seated. Papers shuffle, microphones hum, and the atmosphere turns electric. The judge enters, calm but commanding, the kind of presence that can silence 24 lawyers with a glance. The case is called State of Utah versus Tyler James Robinson. What seems like just another procedural hearing is about to unfold into a fight over control, reputation, and the very weight of justice. The courtroom is stacked. On one side, the state's dream team, Chad Grenander, Jeff Gray, Lauren Hunt, Ryan McBride, and Chris Ballard, each named like a brick in a wall of authority. Across the aisle, the defense, Kathy Nestor, Michael Burt, and Richard Novak, sharp, seasoned, ready to counterpunch. The introductions are polite, even warm, but beneath the civility you can feel it. This is a battleground dressed up in suits. The judge confirms what everyone already knows. The defense attorneys have been formally admitted pro hac vice. Their experience meeting and exceeding Rule 8 requirements. Translation: this isn't their first high-stakes case, and they're ready for a war of paperwork and patience. Then comes the question that always decides the rhythm of a trial. Counsel, what would we like to accomplish today? The prosecution steps up first, crisp and surgical. Under Rule 16 of Utah's criminal procedure, they'll hand over discovery within 5 days. All evidence that led to the charges. But the prosecutor drops the first spark of tension. The discovery is voluminous. In lawyer speak, that means mountains of data, hours of footage, gigabytes of messages, and possibly years of people's lives packed into exhibits. The state promises to cooperate, but the tone already hints that cooperation won't come easy. Then the temperature rises. The prosecutor references a protective order the judge issued over the weekend, one restricting pre-trial publicity. The controversy? A single phrase: all witnesses. The prosecution argues that thousands of potential witnesses, possibly every student who saw the incident at Utah Valley University, can't all realistically be bound by a gag rule. The defense stays calm, deferring to the court's judgment, but everyone knows what's really at stake: the control of the narrative. If one side talks out of turn, headlines could destroy the case before it ever reaches a jury. The judge listens, measured and deliberate. His ruling walks a razor's edge. As witnesses become known, each side shall inform them of the order. No one wins the point entirely. What he gives them instead is responsibility and a warning. Leaks will have consequences. Then the defense takes the floor. Their move is strategic, almost cinematic, no waiver of the preliminary hearing. They want it on the record, but they also want time, 30 to 60 days, to process what the state admits is a massive amount of digital evidence. Translation: they know the state's case is complicated, and they're buying time to dissect every bite of it. Their tone is professional but firm. They won't be rushed into a fight without knowing every weapon on the battlefield. The judge proposes October 30th at 10 a.m. for the next hearing. Both sides agree, but before the gavel drops, the judge decides to speak, and the tone shifts from procedural to profound. His voice carries the kind of gravity that makes everyone stop typing. Mr. Robinson sits before this court presumed innocent. That presumption remains unless and until each element of every offense is proved beyond a reasonable doubt. He pauses, lets it sink in. Then he pivots. Victims, too, are entitled to fairness, respect, and dignity. The courtroom feels the weight of it. It's not a lecture. It's a declaration. No shortcuts, no bias, no games. He continues, pledging transparency, fidelity, and impartiality. I will not put my finger on the scale of justice, he says, a line that could headline any legal documentary. He orders that Robinson appear in person at future hearings, not over a screen, not as a name on Zoom, because justice, he insists, must be faced head-on, human to human. It's a rare moment of moral clarity in a system built on argument. The judge reminds both sides. Regardless of who is watching, whether the nation or a single individual, we must fulfill our roles with integrity, civility, and diligence. The subtext is unmistakable. This case will draw eyes, and no one in that room can afford to stumble. The prosecution responds with rehearsed professionalism. We commit to approach this case with integrity, professionalism, and civility. We are truth seekers, but everyone in the gallery knows the unspoken truth. Truth is about to become the most contested word in Utah. The gavel drops. Court is in recess. But the drama has just begun. In less than 10 minutes, the foundation for months of conflict has been laid. Discovery wars, protective order landmines, and a looming preliminary hearing that could make or break both sides. The judge's closing words echo in the silence. Neither Mr. Robinson nor the people of Utah deserve anything less than the fair and impartial administration of justice. Outside, cameras wait. Inside, lawyers whisper. The stage is set, not for spectacle, but for something rarer. A legal showdown where every word, every deadline, and every leaked sentence could tip the scale. October 30th, the next round. Until then, the only question echoing through courthouse halls is the one no order can silence. When the evidence finally speaks, whose truth will it tell?